multiple international MNCs, including big fours like EY, and I have been working with the Accenture Middle East and other organizations in my past. And I work predominantly with government sector, BFSI, insurance, and other specific domains, and have a good sectoral knowledge as well. So I have credentials including fellow in privacy, CIPPE, CIPM, CISA, FIPT OneTrust, which is fellow in privacy technology from OneTrust, and CSA Star. So these are the different credentials I have, just to make you give you a question that you are definitely on the safe hands. So I'll be going through the agenda again, interest of everyone. So yesterday we covered about the introduction to data privacy and different IAPP certifications overview. We did discuss about why you should do CIPP and why should you opt InfosecTrain. I'll again quickly cover those elements today as well for the new people who have joined. Review of important topics in CIPP exam will be the core crux of this entire workshop. We will be starting with 3 different chapters today. And exam strategy and roadmap, I did discuss about a quick overview. I think we will discuss them in detail today. And we will also cover exam CAPP mock exam questions. And we'll also cover a few data privacy interview questions. And I'll be sharing some free templates and resource part of this workshop. So kindly tune in for all the 5 days of the workshop. I'll be covering different sections of the agenda during those 5 days. All right. So today we are at day 2, and so I'm going to give a quick overview for the people who have joined today. So we have different variants of certificates, certification CIPP, CIPM, and CIPT. CIPP is about understanding the different legal or laws around the world. So there are 4 different variants within CIPP, which is CIPPE, which is GDPR and European Data Protection Law. The second variant is CIPP US, and third variant is CIPP Canada, and fourth variant is CIPP Asia, right? And we predominantly focus on CIPPE, which is GDPR, because it's considered as a gold standard. If you understand one global data privacy law, it will usually help us to equip yourself in interpreting any other data privacy law in the world, right? So that is the reason we usually follow the gold standard, which is GDPR. If you understand that law, even the Indian PDPP bill, it will be only a matter of 10 to 15% variation that could be there in terms of terminologies, or there are certain places there will be few new terms introduced, but that's something which is easily adaptable. So that's the reason we should understand one law in detail when it comes to your data privacy career. The second course is CIPM, is Certified Information Privacy Manager. So it's the only certification that focuses on on your day-to-day data privacy operations. How do you work as a data privacy manager? How do you handle your data privacy program? How do you build a program from scratch, starting with your vision, mission, data privacy framework, your strategy, operating model, policies, procedures? How do you build a notice? How do you actually manage consent, data subject rights, data breach management, data training and awareness? All these things will be discussed part of your CIPM course. And finally, CIPT is Certified Information Privacy Technologist, and in CIPT is a very interesting course for any tech savvy person who are in the domain of development, or they are part of building solutions and tools. So how do you embed data privacy into the solutioning and into the development arena of your organization? So it's a benchmark for the professional to validate the knowledge of privacy requirements. And so it's a interesting certification for people who are tech savvy and they want to completely be in the technology domain. So FIP is not a certificate, it's an accreditation. If you finish 2 out of these 3 certifications, then you will be eligible, and you need to showcase 3 years of experience, plus you need to have some referrals. With that, you will be able to get this coveted title of IAPP Fellow of Information Privacy. It's a very prestigious accreditation. It will really demonstrate you and your experience in data privacy market. All right. So why InfosecTrain? This is a very important question I have been answering to many people who were is opting this particular training program with us. So if you go to any other training institute which are providing data privacy training, they generally offer you 12 hours or 14 hours or 16 hours. But at InfosecTrain, we provide 32 hours of instructor-led training. That's a clear differentiator. The reason is the topic whichever we are discussing is very complex. It is a law which we are studying, and we need time to digest the requirements, right? You need to go back, go to your drawing board, learn learn the materials, read the different requirements which I share over the weekend, come back with the questions, clarify, and then move on to the next topic, right? So in this course, I'm not just planning to make a candidate just pass the exam. I'm trying to build a candidate to have a fruitful data privacy journey, or making them eligible for having a fruitful career in data privacy and data protection, right? So that's a clear differentiator when you come to InfoSec Train. And so if you come to me and ask, I just need a dumps to clear the exam, definitely InfosecTrain is not the right place to come for you. And we never look into shortcuts. We are always looking forward the right way. We want to train you, and we want to make you part of a privacy community to grow along with us. And that's the clear differentiator when you come to InfosecTrain. And we will always guarantee you the lowest price if you can compare yourself in the market. And approved and certified instructor with FIP, and I'm an approved IAPP trainer. Career oriented skill based course. You will see a lot of industry examples when you come to my course, and these examples are direct derivation of what people face challenge in their day to day work. Mock exam is included part of the package. And finally, we part of this offering, you will get the IAPP ebook, which is the official textbook, and you'll also get the participant guide, which is the day-to-day content which we'll be discussing, plus the exam voucher of and a 1 year IAPP membership. So this is all included for the package when you join us with InfoSec Train. If you opt yourself, you are going to almost pay the same fees without the textbook, without the ebook. Okay. And that is the reason I would say when I did my certification, I didn't go to a training, but I paid almost the same $800 to just register for me into the exam, as well as to pay the certification maintenance fee, right? So which means getting these training plus getting the ebook and the IAPP participants guide at a cost which is almost equals when you do it separately. It's a win-win situation, right? So it's a heavily subsidized priced when it comes to the training. So you should definitely look forward it. I'm not promoting that you should join only InfoSec Train, but I would recommend that go for such training, because the cost of such training along with all these materials is almost the same cost when you pay it independently when you take up this exam, right? What is a key differentiator from other vendors? So we provide 32 hours of practical and quality preparation with sufficient time for you to understand complex topics. So that's a clear differentiator in the market. It's a case study approach. Yesterday, you would have seen a lot of case studies for each of the topics. That is the way I generally take up my sessions. It's not theory. Templates and other useful resources are included part of the session. I generally share a lot of templates, like how do you build a ROPA, how do you do a PIA, DPIA. I'll share a lot of working documents, and I do conduct a specific exam strategy session and exam support. So I give you clear guidance in terms of how do you strategize yourself for the exam, what are the do's and don'ts, what are the important materials which you need to practice. And finally, I keep supporting as a community. I've been last 2 years, there are uh, lot of people who have cleared under my guidance, and we work as a community. And so we are still in touch. We are all part of the same forum. We help each other, we grow together. So that's a wonderful place to be part of if you are going to start your data privacy journey. And I do help for people who want to shift into data privacy domain. For people who are like just out of the college, I provide a lot of career guidance. And people who are shifting with after a lot of years of experience, maybe 10 years, 15 years, they want to jump into data privacy, how do they structure their career? I do help them, suggest them what are the right steps to take. So these are the clear differentiators when it comes to InfoSec Train program, what we deliver here. All right. So this is the exam roadmap, which is very specific to the CIPP course. For the people who are joining today, so this content was not covered yesterday. This is the exam strategy roadmap, which I'm clear prepared for the participants. So the first step I would always recommend is book an exam slot, fix a target date. So this itself will actually take care of majority of your exam related doubts, right? Once you actually book the exam date, it will give you a lot of clear focus. This give you fear as well as the focus, and it will definitely help you to streamline your efforts as well. Generally, people say this itself is 30% of success in terms of clearing any certification exam. And don't worry, if you book an exam date, you always have an option to reschedule the exam 48 hours before the exam day, right? So it's not like if you book the exam date, it is not irreversible. Within the 1 year period, you can always go back and change the exam date. So don't worry, but booking an exam date will always give you the correct path, how many days you need in hand, and how much effort you need to keep it. So generally 45 days is what I suggest to the candidates, 30 days of my trainings and another 15 days for you to practice the Q&A. You can also give the exam within 30 days as well, for which you need to put some extra effort, right? Which means you need to you need to practice the Q&A along with my training, which is very much doable, right? So 30 days of continuous preparation is definitely sufficient. I had candidates who have cleared in 3 weeks. I had majority of my candidates who cleared in 4 to 5 weeks. So it is 100% doable. Just that you need to commit yourself and just follow whatever requirements I mentioned during the training, and it's definitely doable, right? So the first 3 to 4 weeks, what are the important requirements? You need to read the official textbook. The official textbook is from European Data Protection Law, which is by Edward Ustran, and that textbook should be read along with the materials which I covered during the session. So IAPP participants guide, which we will be discussing on our day-to-day course, will uh, will be having 11 modules, but there are 18 chapters in the official textbook. But don't worry, all the curriculum is definitely covered in the participants guide, which we will be discussing. The only important point is those 18 chapters are for elaborate reading on the course curriculum, right? So only request which I ask all my candidates is that start reading the textbook from day one. So after the 30 days, you should have done the reading and you should directly go for your Q&A, right? So reading the textbook and listening to my training and just going through the participant guide at least once is a minimum task for you to complete in the first 3 to 4 weeks. Now coming to the practice test. When it comes to practice test, there is a big myth in the industry, and also there is a lot of misleading information which is available there, right? So you should not practice any dumps which are free in the market. The reason is they have at least 50 to 60% of wrong answers. This can have a big problem in corrupting your memory as well as your logic, right? So that's the reason I always recommend just go for the official practice test, whichever I recommend. Do not take any other practice test outside, because they have it. I don't know who has done this purposefully. They have 50 to 60% wrong answers, and people who believed that just with dumps they can clear the exam, they have failed miserably. Okay, I know at least so many candidates who took that shortcut, and actually IAPP is very particular. They are revising the question and answer continuously. So believe in a right way, and right effort will definitely fetch you the certification, right? So I have created a list of practice exams which I recommend for you in the order which I have mentioned. Start for a foundation level, which is crush the GDPR in Udemy, and the second one is Jasper Jacobs Red Book in Amazon. So all these are available in the format of EPUB online reading, right? It comes at I think 499 rupees. You will get all these formats. And Franklin Phillips from practice exam, I think you will get 180 questions from Amazon. And finally, Majid practice exam from Amazon. So Majid is a bit of optional because it's a bit costly. It comes around 3,500 rupees, but it's again a very sort of a medium to difficult level questions will be there in Majid, right? So the questions somehow give you a sense of what you need to what you can expect in the exam. But there is one important material which all of you should practice is your IAPP official Q&A. Okay. So IAPP official Q&A is a very, very important material because that gives you a near exam simulation. So those 90 questions you need to purchase from IAPP, and that gives you a perfect clarity in terms of where do you stand ready for the exam, right? So in the same order, which if you can practice it, you can definitely complete all these elements within 1 week. All right. So you must read and be very familiar with GDPR articles, actual wordings which are used. So GDPR is the actual legal text is open source material which is available, and the articles 4 to 50, 84 to 91 are very, very important. What I generally tell my candidates is that please take a printout of the official text and start making your own notes in that printout, right? So if you start reading it day by day, you will definitely get familiar with the actual wordings. You will be not required to memorize all these actual content, but each of the word which is present in GDPR articles, there is definitely a lot of inference which you need to understand. All right. And there are other open source material which are available with IAPP, which is your CIPPE body of knowledge, which is the actual course curriculum, which outlines what are the important topics you need to prepare for the exam. And you should make sure you have a fair idea about all the topics. Another clear guidance I give my candidates is that if you open that body of knowledge before the exam, right? And if you are able to remember each of these topics, and if you are able to speak for 10 to 15 minutes, what is this topic about? So which makes you clearly that you are in a good shape, that you are ready for this exam. That is another way that you can evaluate yourself whether you are ready for this exam, right? Review the exam blueprint to know the chapter wise exam weightage. During the 5-day workshop for each of the chapter, I also mentioned the exam weightage. Each of this chapter, what is the minimum and maximum question you can expect from the exam. So another important document which I share you during the entire course is EDPB guidelines. So EDPB guidelines on controller, processor, GDPR scope, consent, data protection impact assessment, and privacy by design. All these are very, very important guidelines. They have very good examples, not only from the exam perspective, also from a practical implementation perspective. These are sort of a gold standard when you are preparing your uh, data privacy certification. Let it be any certification, these guidelines are very, very important. Simulate the exam with the above resources which I mentioned, practicing 90 questions for 2.5 hours. So this exam is for 2.5 hours and there are 90 questions. So whenever you take all these practice exams, don't take like 50 questions, 25 questions. Always practice in a set of 90 questions for 2.5 hours. So this will help you to adjust to the exam environment, right? So people who are not familiar with your professional certification, I would highly recommend all of you to start uh, uh, to practice in this exam mode. The reason is these professional certification exams, when you take test your questions in silo, you will be able to answer. But under a pressure situation for 2.5 hours, your brain or your attention span definitely needs to be improved and get into a mode of answering continuous 90 questions, right? So you need to train yourself to get into the mode. There are a lot of candidates who do very well when they do 20 questions, 25 questions, but when they take up 90 questions at a stretch, you will feel that you are mentally drained after 50, 60 questions, right? So you need to adapt to that model. That's the reason I highly recommend that you need to take all this 90 question in a 2.5 hour stretch. So use Quizlet application. There's a Quizlet app which is available in Play Store as well as in the web version. So these Quizlet app helps you to remember a lot of important topics. For example, there are 6 lawful bases. There are 7 important data subject rights, and there are 6 principles, right? So all these things can be remembered handily by using such application. And read the IAPP glossary, and ensure that you remember each and every terms which are mentioned part of the glossary. You are aware of it, and work as a team. Discuss your wrong answer and understand the logic behind it. Whenever you give such exam, it is not important that you scored X percentage. It is important that even for the right answer, understand the logic which was explained in the IAPP official Q&A, right? You would have chosen an answer. Maybe it was with a different logic. You got it right. But understand the logic behind each of these questions, right? That's a very, very important factor. If you make a mistake, that is perfectly fine. All of us did this mistake before reaching the level what we have done. So make mistakes, understand the logic, correct your understanding behind it. If you do this, then you will be definitely ready for the exam. A clear benchmark, which I tell all my candidates, is that keep 75% benchmark for all the exams. If you reach 75% consistently, 70 to 75%, 70% is a cat on the wall, 75% is a clear winnings percentage. So if you score 75%, you are definitely ready for the exam, right? So last 2 days before the exam, don't take any test, just revise. So that will definitely keep yourself focused and not create a stressful environment. And as I said, whatever preparation you do on the D day, it's about how you keep yourself calm, right? How you yourself are able to read the question, read each and every word, and not make a error in judgment, right? So it is 50% of your knowledge and 50% of on presence thinking, right? If you are able to think on your feet by reading this question and read every single word, a last word of a question can actually lead to the right answer. So that is why you need to be really calm during these professional exams. And that is what is expected from you to be a data privacy professional. All right. I hope the exam roadmap helped you. This is my exam strategy when I did my exam. So pay attention to the details. There are a lot of similarly worded answer choices. So elimination approach is the best approach. So out of 4 options, 2 options will be similar. 2 options you can easily eliminate. So that is an approach which I will suggest when you're not sure of the answer. Definitely go for the elimination approach. If an answer jumps out at you, go with your gut instinct. By when you read the question, you read the options directly, you see an option, right? That is the right answer, and 99% it remains the right answer. The first reading generally with a fresh mind generally helps you to find the right answer. Don't spend too much time in one question. It's a competitive exam. So if you spend, there are questions which are purposefully set to make you spend long time, because there are two types of question. One is a passage question and there is a factual question. The passage questions will contain 3 to 4 paragraphs, so making you read and spend a lot of time, right? So don't waste too much time on any question. You have to devise your own strategy. Like first hour, how many questions I'll complete, second hour, how many questions I'll complete, and this is the way you can set your own strategy. And if for scenario based question, try to read the question before you read the passage. There are 3 to 4 different passages which are there. I would recommend you first read the 3 4 questions below the passage, then go and read the actual passage. That will help you to scan for the exact content which you need to examine for answering those questions, right? So don't go back over the questions you have already answered. You have an option to flag the questions. So the exam is divided into 2 parts, 45 question and 45 question. After you complete 45th question, you will be asked to review the question whichever you have flagged, or the questions which you have not answered. And once you do that, then only you will be allowed to move to the next section. So after the 45th question, you get a 15 minutes break. And that with the 15 minutes break, you have an option whether to take the break or you can directly go to the next section. So you will not be allowed to cross the next section before completing the first half, right? So that is something which you need to take care. And also you will not have that much time to go back and review each and every question what you have already completed and you're done with confidence, right? So this is the resources which I would highly recommend for all of you. So official text from the GDPR law, and EDPB and ICO guidelines. From IAPP, you get body of knowledge, which is the curriculum, exam blueprint, and the certification candidate handbook, which helps you to whatever we discuss will be covered there. And European Data Protection third edition, this is the official textbook. And you can also look at overview videos like GDPR overview under 60 minutes. And this is a CIPP overview, which I have provided. You can also check that. And exam practice, which I mentioned already, I have summarized here. So these are the official different exam practice which you can opt for your CIPP practice. Okay. So this is the exam blueprint in terms of, for we have 18 chapters. 18 chapters, we have minimum and maximum questions for different topics. And this will help you to strategize in terms of where you need to focus your attention. And remember one thing, the exam has sectional weightage. You just cannot put complete focus only on section 2. If you actually don't get the required percentage for section 1 or section 3, you may still fail in the exam, right? So that's a very important point. You need to get a sectional weightage for all of these courses. So don't look into just focus on only one section. You need to equally score in all the 3 sections. All right. So this is the exam blueprint in terms of what are the minimum and maximum questions which we will be covered. So yesterday we started with data protection concept and territorial scope, and today we will start with data privacy principle, lawful processing criteria, right? So we are also launching a CDPO course. Course fee and everything you can check out with the sales team participants, so that you will get a clarity on that. So we are also launching a CDPO course, which is Certified Data Protection Officer. So this is the agenda of this particular course. And these are the different components of it. And it's a completely hands-on course. We will be discussing on building the data governance part, and we will be discussing on how to do manual data discovery, how to build a ROPA, and how to define your retention requirement. We'll be looking into the privacy by design and security of processing control perspective, assessments like DPIA, PIA, and also looking into third-party assessment. There is an error. This is actually legitimate impact assessment. And data subject rights management, data breach management, and data transfers, including transfer impact assessment, standard contractual clauses, and binding corporate rules. And finally, how to build cookie notice and consent. So all these things will be discussed on a hands-on model. So it's a 24-hour course, but there is a prerequisite. You should either have completed my training on CIPPE, CIPM, or have taken a foundation training with us. So this is a direct hands-on session. So you will not be covering all the basics in this course. It's a direct course when it goes to. So CDPO is from InfosecTrain. IAPP doesn't have a CDPO certificate for. So we'll not be getting a IAPP certificate, but this is a InfosecTrain course, and you will be required to clear exam, which will have 50 questions, and you need to score 70% to get a pass the CDPO course. All right. So we also provide a combo course of CIPP plus CDPO or CIPM plus CDPO. These are ideal combination for you to get the data protection officer role in the market. So these are excellent opportunities for you to groom yourself. And we also have a lot of data privacy consulting services running on InfosecTrain. So we do provide services on data discovery and data classification, compliance assessment like gap assessment, recommendations and roadmap, and compliance assessment and privacy program management, building your policies, procedures, and creating those templates, and cookie compliance assessment. How do you evaluate cookie compliance for your website and for the different collection endpoints, data inventory, building your ROPA, and conducting various data protection assessment and data processing agreements, supporting on data subject rights management, and benchmarking study of evaluating the data privacy tools for your organization. And if you need a staff augmentation, we'll also help you on that. So these are the different components. We do provide data privacy consulting services. If you need any help for your organization, if you want to look into the you will need any support for building your data privacy program, we are always there to help you. So with that, I'll be starting today's agenda of data processing principles. All right. I will take a couple of minutes just to look at some of the important So I will cover the course content now and then move on to the topics for the questions later on once I complete the session. So in today's session, we are going to look into the data processing principles. So in GDPR, we have 6 important principles. Okay, so which is lawfulness, fairness, and transparency, purpose limitation. Uh, so these are the actually there are 6 principles and there is one principle which is embedded part of the data privacy framework, which is accountability. So the 7 principles which you need to understand in depth are starting with lawfulness, fairness, and transparency, purpose limitation, data minimization, accuracy, storage limitation, integrity and confidentiality, and accountability. I'll be giving a lot of examples to understand each of these principles one by one. So what is lawfulness? So if you are going to use 6 lawful bases which is defined in GDPR for processing any personal data, then you are following the lawfulness principle. So lawfulness principle is very straightforward. GDPR has permitted you to process personal data only based on 6 approved ways, right? They are called lawful bases. If you do that, then you are adhering to the lawfulness principle. What is fairness and transparency? So fairness means you are processing a personal data in a fair way that data subject expects you to do. Example, if you are collecting a personal data, do not trick a person to give his personal data. For example, when I go to a website, a lot of times I am being tricked to click a box, a tick box, or sometimes just by scrolling the website, it is considered as a deemed consent, right? So these are not absolutely fair processing. And if there is a processing activity that can have a negative impact on the data subject, then it's not considered as a fair processing, right? And what is considered as a transparency? So transparency is whenever you are collecting personal data from any data subject, you need to ensure that the data subject is absolutely clear with the processing activity. He's been provided the required information to make a clear decision, right? So you mentioned you provide a privacy notice, inform them about the processing activity, what is the purpose, how long you're going to retain, with whom you're going to disclose the data, is there an international data transfer bound, how do you going to protect the data, and all these, and what are the rights which is there for the data subject to exercise. If you transparently provide this information, then you are upholding the transparency principle. So this is the first principle of GDPR. The second principle is purpose limitation. So if you are collecting personal data in an organization, you always map that collection to a particular purpose, right? For instance, if I go to a showroom to buy a car and I need to fill my personal information to create a quotation, and the information whichever was shared, the company will be sending me some information about a car, whether the car is available or the next further stages like the car related to purchase, their information will be processed, right? The same information which is being utilized for an unrelated purpose, then it is a violation of purpose limitation. For example, the company decides to sell the data to other agencies which they can send some direct marketing messages to the customer, then it's said to be violating purpose limitation. Purpose limitation purely says that if you collect a data, stick to that purpose, and you do not trick a user or by asking them for bundled consent, right? So you don't ask them to you provide 10 purposes and ask one consent, or you do not use the data for unset purposes, right? Whenever the organization collects the data, there are always lot of opportunities for them to use for many purposes. Like the company wants to decide to do some analytics and they want to use the data from some direct marketing activities, but you need to check, did we mention these purposing activities when we collected the data? Is the data subject aware about it? So this is all the important questions we need to answer when it comes to purpose limitation. The next concept is data minimization. So data minimization is very simple in terms of understanding the necessity, the relevancy, and the adequacy, right? So whenever you're collecting the data, you need to ensure that you are collecting adequate amount of the data. Do not collect excess data. Do not collect less amount of data to fulfill to ensure the processing activity. Second is relevance. So if you go to a bank, you will generally fill a KYC document. The fields which are collected in a KYC document should be absolutely necessary for processing that particular bank account, right? If unnecessarily there are information which is collected in the KYC, then it is violating data minimization principle, right? So wherever data is gonna collected, you need to see whether relevant data and limited data is collected. If you collect excess information, if you collect unrelevant information, then definitely you are violating data minimization principle, right? So a classical example is using a biometric authentication method in a company for logging into the office. For example, you can have access control. You can have your PIN number for an employee, like for a dual authentication. You don't need to have a biometric authentication at every single place, right? It makes sense, depends on the sensitivity of the activity. For example, in a bank treasury, it makes sense for the bank manager or the top management to enter into the vault. You can have a biometric authentication. You don't need a biometric authentication, for example, in a school, to enter into a library, to enter into the school. You don't need to collect the biometric data, right, which is your fingerprint. So this is again data minimization principle in practice. You need to understand the processing activity, and you need to collect the data which is adequate, relevant, and limited. The next principle is accuracy. Ensure the data, whatever is collected, is accurate during the entire life cycle. So you need to give provision for the data subject to ensure that the data can be updated during the course of the life cycle. Example, I changed my address. There is a change in my mobile number or contact details. So there should be provisions available for the data subject to change the personal information, right? So this should be done at a free of cost, and it should be available in a easy available option, right? That is the accuracy principle. And storage limitation principle. So whenever we are storing the data, ensure that the data is stored only until the time limit which is required to fulfill the processing activity. Very simple. If you collect an employee's data, retain the data till the employment, plus you have a legal mandate, maybe 5 years or 10 years, you need to retain the data, because there is a legal requirement for employment data to be retained after the employment as well, right? So it could be employment plus 5 years. That's the retention period, right? So we need to clearly set retention period for each and every personal data that is collected in your organization, right? So this is called storage limitation. Never store data in excess, never store in data beyond the retention period, right? So there are certain exemption when it comes to storage limitation. We will be discussing all those things in detail during our course. Uh, Integrity and confidentiality. So integrity and confidentiality is about how do you ensure the CIA perspective of your personal data? How do you ensure confidentiality when you're transmitting personal data from one entity to another entity? It could be your controller and processor scenario, or processor to sub-processor scenario, and also ensuring the integrity and availability aspect as well. This is the integrity and confidentiality principle. And next is accountability. So accountability principle requires an entity to demonstrate accountability in terms of having a proper data privacy governance, which is establishing your policy procedure, appointing a DPO, maintaining the records, which is including your data inventory, conducting a DPIA, right? And also embedding data protection by design requirements into your data lifecycle. So this is the way you will ensure accountability of an organization with GDPR. I hope everyone are able to understand the 7 different principles of GDPR. XYZ Widgets Limited collects personal data from users on its website, stating that purpose is to enable users to be authenticated to their secure portal. The same data is then used by the marketing department to profile site visitor to target advertising across many different websites. So which particular principle is getting violated? So this is a very exam simulated question. You can expect such question in the exam. What else? Purpose limitation and lawfulness is the right answer, because you are exceeding the purpose for which you are collected, as well as you are not having a proper lawful ground to process the data for other activities, right? So it is violating both lawfulness, and purpose limitation. So it is not violating integrity and confidentiality and other aspects, because it is purely a case of not having a lawful ground and you are exceeding the purpose for which you collected the data, right? Sorry, I just scrolled it. So the second case, a gaming company asks data subject to provide their copy of passports and driving license to authenticate data subject to fulfill the data subject rights. Company never collected this information when the user subscribed to the services. So there is a gaming company. So a data subject wanted to, for example, they want to delete their information from the gaming company, right? So they went to fulfill the data subject rights, but to fulfill the rights, the gaming company is asking, please share your passport and driving license to authenticate the data subject. So to even fulfill a data subject rights, you should always use less intrusive method and never collect excess personal information which is not originally with you, part of the collection process. So in this case, what principle is getting violated, team? Anand says data minimization, Shweta says minimization, Yogesh minimization. I think almost all of you got it correct. It's data minimization principle which is getting affected. Let's go to the third case. A bank maintains customer database with email and postal address to provide accurate statement for financial year to its customers annually. Customer can update the details through online portal. However, mailing list is stored on separate spreadsheet, which is updated quarterly. In last quarter, 30 customers updated their address details and 20 updated their contact preferences, stating that they do not want to receive any electronic version of the document or the account statement. Due to a staff change, there was a manual error, human error. The spreadsheet was not updated for the last quarter, and 30 customers missed out on their statement, with further 20 receiving a physical version, which they clearly said they didn't want to receive. Answer is accuracy, right? So this is a clear case of an accuracy error. The correct data is not getting, and it's also leading to a data breach in terms of the availability is getting questioned here. The data should have been available to the data subject, which is not available, and also people receiving a version which is not as per their preference, right? So the principle which is getting violated is accuracy. Let's go to the next case. An IT company saves the candidate information who got rejected during interview. They do this for the legitimate interest of not allowing candidates to appear for the same position within 6 months period. The company retained this information more than 6 months and used it for blacklisting purposes. Answer is storage limitation, purpose limitation, and data minimization, right? Because you have stored the data more than the actual purpose, which is ideally 6 months beyond the retention period. Second, purpose limitation is because you have used the data for unset purpose when you collected the data from the candidates. The third is you didn't follow the data minimization principle because you are using it for blacklisting purposes, which is not actually accepted as a ethical practice as per GDPR. You can never do blacklisting for reasons like candidates failing in an interview, right? So the three principle which is getting affected is storage limitation, purpose limitation, and data minimization. Next case, e-commerce company in its website use dark patterns by tricking the users to give consent for marketing cookies. So what is dark patterns? You would have seen websites where accept is in a very bold and bright colors, and there is a reject or deny in a very small, or it's not even visible in a website, right? So there are multiple dark patterns. It's an interesting study where they are trying to trick a user, right? So to give a consent. So this is called dark patterns. There is a lot of study which has been going on how the users have been tricked visually to go and compulsory click accept all. So this is called dark patterns. And if you use a dark pattern to trick a data subject to give a consent, which particular principle are we violating? Answer is fairness. because it is definitely violating the fairness principle when the personal data is collected to assess. So there is another point, right? Fairness also speaks when the processing is negatively going to affect a data subject. It's said to be unfair processing, but there are certain exemptions. For example, a bank collect your tax liability, right, and it shares that information to the income tax department. But this particular processing, it can have a negative impact because you might be getting a tax liability from the tax authorities, right? Or for example, if you are doing you are getting a speed challan when you are traveling in a motorbike, right? You get a first challan, and in next 2 to 3 days, if you again do a overspeeding, you may get a aggregated challan. Like for example, they would have seen your past behavior, and you may get a excess penalty in this case, right? So even in this case, such processing activity can have a negative impact on you, but these are exemptions when it comes to fairness, right? So fairness, you need to look at if it is a negatively affecting the data subject or tricking a data subject to do an activity, it's said to be a unfair processing. Okay. Hospital stores patients' health information in its database in plain text. It also provides telemedicine services where patient can interact online with their doctors, and the medicines are prescribed over email. Hospital network was hacked and patient health information was altered to cause reputational damage for the hospital. So in this case, what principle is getting violated? Answer is right. Integrity and confidentiality principle. That's great. So this is all about the different principles of GDPR. And these are the exam simulation questions, which you can definitely expect such similar questions in the exam. So exam will have 4 different options, not exactly in this model, but a similar context and similar way, it will put you to think what exact principle is getting violated. Instead of just one answer here, they will give you 4 different principles, and you need to select the right principle. That will be the exact exam question which you can expect. All right. So any questions on this? If you have any doubts, please what is difference between ISO 27701 PIMS and CIPPE? So PIMS is a standard like ISO 27001. CIPPE is a study of legal requirement, right? So there is a law called GDPR from Article 1 to 99. It's a mandate. If you are an organization established in EU, you need to follow those requirement as an obligation for controller and processor. Whereas 27001 or 27701 is a standard. It prescribes you a set of controls, and if you fulfill those requirements, then you get a certification. If you for following GDPR, you don't get a certification. If you don't follow, you get a penalty. It can even completely stop your organization from doing the business as well. So that's the difference. See, your standards help you to fulfill legal and regulatory requirements, right? So that is the key difference. So 27701 is actually trying to ensure all the components of the law is getting covered in terms of obligations of a controller and processor. That's the major difference. Go for CIPPE instead of 27701. 27701, you can always do it in the future when your organization is going to implement it. Or if you are going to look for a lead auditor or lead implementer role, then you can go for 27701. A CIPM syllabus also going to change every year. There is a routine change that happens for CIPP and CIPM. So don't worry about it. For the fees part, you can reach out to the team. Okay. We'll get recordings. Yes, you will get. What is the data retention applicable for education sector on a conditional basis, because they may have certain retained students. So you need to look at the HR, human resource department when it comes to education institution. As I said, your retention period gets affected by the legal, regulatory, and other contractual requirement as well. So you need to look at that perspective before you define your retention limit. Can a beginner to a security field take this training and exam? Absolutely yes. Many candidates fresh out of college from your engineering or from legal have cleared exam with me. PIMS is a standard. CIPP is about studying a law, which is your legal requirement, and ISO facilitates your fulfillment of legal obligation. So standard helps you to ensure you have your best practices implemented. And one of the first requirements you fulfill part of any standard is complying with your legal regulatory requirement, and that is all you study in CIPPE. So CIPPE is non-negotiable, which means if you're an organization operating within GDPR territorial scope, you need to fulfill CIPPE, so CIPP requirements, which is GDPR requirements. But ISO standards are optional, right? You don't need to actually, every organization doesn't have a mandate to do a standard like ISO, but it's a best practice. Many governments or many laws, in fact, now recommend to have some baseline standards, so that helps you to fulfill your legal and regulatory requirements. All right. Uh, Hope that answers all your questions. Let me move to the next chapter, which is your lawful basis. Okay, so there are 6 lawful bases for processing personal data in your GDPR material scope. So the 6 lawful bases are: first is consent, second is contract, third is legal obligation, fourth is vital interest, fifth is public interest or public task, and sixth is legitimate interest. Let me explain them one by one. What is consent? So consent is a foundation for any data privacy law, which was empowering the data subject to take his own decision when he can understand the processing activity and agree to a processing activity. That is called consent. So if you are collecting a personal data from an individual, you need to provide notice in terms of making them understand what is this processing activity about, and then collect their consent in a affirmative way, right? So this is called consent. Individual gets the right to decide to give the data or not. There are important attributes when it comes to consent. You cannot force a person to give his consent. That is the reason in during employee employment scenario, we never consider consent as a valid lawful ground. Okay, and we generally rely on contract as a lawful ground, and that is something which is very, very important for you to understand. Consent cannot be forced. Consent should always have a reversible option. Consent should be an informed consent. Consent should be not bundled. There are a lot of attributes which you need to fulfill when you are using consent as a lawful basis. Okay. The second is contract. Contract is very simple. Whenever you go to a grocery shop, you're gonna buy some products, and in this session, sorry, in this case, you are trying to pay for the goods which you purchased, and the seller is actually trying to collect your information to do the transaction successfully, right? Part of this, your personal information is getting transacted. Maybe you're paying via card, or you're asking for a home delivery. So this is a classical example of a very basic level of contract. Contract exists both verbally as well as written. Not only it is not only that you should think of a written contract, right? So contract generally is predominantly used for goods and services and also employment perspective, and it is the most prevalently used lawful basis for processing personal data, right? The third is legal obligations. Whenever the law mandates you to process personal data, collect the personal data, you can use legal obligation. Classical example, like banks need to collect and share the information about your earnings and your credit information and debit information to the authorities. This is a legal obligation. Similarly, there are so many legal obligations which is mandated by the law, and it needs to be fulfilled. That is legal obligation. Fourth is vital interest. So vital interest is one of the least used lawful basis. It is used only at times of crisis, right? Whenever there is a life and death situation, only in that situation you can use vital interest. Let me give you an example. So if I have, if I am being injured in an accident, my leg is injured. In this case, can I use vital interest? Answer is no. If I'm able to speak, I can speak for myself, then you should not use vital interest. But in a situation, a person is in coma or is in a state where he is not able to speak for himself, then you can look his personal data, like getting his blood group, taking his ID card, looking for the contact information, informing his company or for the close relatives, especially in hospital scenario. All these things are accepted under vital interest. The next lawful basis is public task. So again, this is predominantly used by government agencies. So government collects Sensex. During COVID situation, a lot of information was collected about health data. So for fulfilling all the different services which you avail under government schemes, you need to share your personal information, right? So that is done under a valid lawful basis called public task. The next one is legitimate interest. So legitimate interest, which is a very tricky area when it comes to lawful basis. So companies can use legitimate interest as a lawful basis for selectively or narrowly interpreting certain processing activity. Let me give you an example. Whenever a candidate joins a company, during the enrollment process, you will see there is a background check initiated on the employees, right? So that is an example of your legitimate interest. Companies installing CCTV cameras. Companies actually having employment monitoring schemes. Like for example, they monitor your website actions or login logout time. There is a lot of things they do part of your employment monitoring, correct? So these things can fall under legitimate interest. Even direct marketing activities fall under legitimate interest. So under this particular lawful basis, you should do a clear documentation, which is called legitimate interest assessment. We call it as LIA. LIA is clearly needed to demonstrate that you are not misusing this particular lawful basis, and you should the data subject should not overpower the legitimate interest using their data subject rights. It's a complicated statement which I said. It's very simple. When you exercise your data subject rights, we will have this dedicated chapter in the upcoming sessions. Data subject right, one of the rights says right to object. Right to object can be used if it is based on certain legitimate interest like direct marketing, and you need to ensure that you are using legitimate interest in a clearly appropriate way. You need to fulfill necessity, relevancy, and adequacy elements when it comes to legitimate interest. All right. So let's move on to the last topic, which is information provision obligation. So so this particular chapter covers around 5 to 8 questions, minimum 5 and maximum 8 questions. So this chapter speaks about whenever you are going to give information under your data subject rights, or whenever the information is getting collected, you're going to provide this information through your notice. How do you provide this information? How do you ensure transparency? And what are the exemptions which is there in terms of providing this obligation? And what are the intersection when it comes to e-privacy directive? I'll not be able to cover all these topics. Let me try whatever topics is there. So whenever you are collecting such information, you need to look at the the mode of collection. Are we collecting the data directly? Are we collecting the data indirectly, right? So when the data is directly collected from the data subject, these are the typical information which you need to provide. And when the data is getting collected indirectly, you need to provide all this information. Plus, you need to provide two more additional information, which is what is the source of data and what are the categories of data you collected. All right. So let's look at the details which needs to be provided whenever you collect the information directly from a data subject, which is your identity and contact details of your data protection officer or a concern authority. In Indian scenario, you may say a concern authority or a grievance officer who will be responsible for answering your questions. Second, what is the purpose for processing, including the lawful basis? We studied there are 6 lawful bases. So mention under which lawful basis you are collecting this data. Is it a contract, or is it a legitimate interest, or is it a consent? You need to mention that. Legitimate interest of your company. If it is based on a legitimate interest, you clearly need to mention, is it based on legitimate interest, and you need to further specify why it is legitimate interest. Categories of personal data collected. Are we collecting sensitive personal data? Are we collecting children's data? We need to clearly mention categories of personal data. Sorry, what I mentioned is categories of data subject. Categories of sorry, this is correct. Personal data, sensitive personal data are categories of personal data. Categories of data subject is also important, which means it could be of children's, or if it could be of people like elderly people. So not necessary in GDPR, but certain regulations try to see, are you collecting vulnerable people's data, and recipients or categories of recipients of this personal data. For example, the data is getting transferred to a processor, or the data is getting transferred for any third party in your own environment. Then try to list it down, where is the data is getting transferred, and if the data is bound for any international data transfer, you need to mention that. Part of the transfer, what are the security safeguards you have implemented in your organization, and how long you will maintain this data, which is the retention period. Existence of data subject rights, what are the different rights which is available for the data subjects, and right to withdraw consent where relevant. For example, if the processing is based on consent, you need to mention that you can withdraw your consent at any point of time. Right to lodge a complaint with the supervisory authority. This is specific to the European Union scenario. So you always have a right that you feel something is wrong. You can go to the supervisory authority and inform him this is not right. And data source, what is the data source? For example, is this indirectly collected? Then you have to mention that. Statutory and contractual obligation and consequence. For example, if it is like, what are the obligations of the controller regarding this particular processing activity? So these are the certain information which needs to provide it. So there are different mode of providing this information. So okay, so if you see, the information has to be structured in a privacy notice, and there is a classical problem when it comes to privacy notice being very, very legal and heavy worded, right? So that's a challenge, and GDPR has understood this challenge and said that whenever you're developing such notice, you need to ensure that the reader are able to understand such privacy notice. Like they have suggested, like you can opt for a layered notice, which is like dividing the content of the privacy notice into a high level first layer, which is the purpose of processing and the contact details of the controller, and then move on to the next sections, which is like the purpose, for example, the data disclosures in terms of the controls, the retention period, and then finally go into the fine prints of the requirements, which is mentioned in this table, right? So this is called layered notice. You can also go to other innovative ways. For example, if you go to, I think, Twitter or Facebook, they have come up with gamification for privacy notice. You can actually play it as a game to understand how do they process your personal data. So these are some of the innovative ways you can do privacy notice. Especially when you're collecting children's personal data, you need to be aware that the children are able to understand the processing activity, right? So your terms should be very simple worded, and it should be clear instead of making it legal jargons, right? So this is something which you need to be mindful and look at different formats. For example, if you're presenting a privacy notice in a mobile, you need to look at this innovative ways. For example, in the diagram which is mentioned, ICO has suggested bring your icons to demonstrate majority of the information along with a tagline. So whenever the user is interested in any particular section, let them go in detail, but don't dump them with all the information like 10 to 15 page privacy notice. No one will be interested to read such detailed privacy notice, correct? Except the lawyer friends who are there in the session. So this is something which we should be absolutely mindful. So this is consent. I am borrowing it by Privacy by Design Training Institute. So so consent attributes we discussed already, that consent should be freely given, informed, it should be specific and unambiguous. And there is active consent versus passive consent, which I told you, like there should be like ticking a box saying yes, confirming with email. Passive consent is your implicit consent, right? Passive consent is not accepted in GDPR. We should be clear about, and look into deceptive and manipulate. This is the dark patterns which I mentioned you during those topics when we discussed psychological techniques to nudge and manipulate or coerce or browbeat or otherwise claim that permission has been obtained. Just example is like when you log into website, you just by scrolling at people say that you have consented, right? So that's a clear deceptive pattern. A supervisory authority is an independent body. It is a legal independent body. It is appointed based on the law that the every member states in the European Union have a supervisory authority. They are supervised by a body called EDPB, European Data Protection Board. These we will discuss in the exclusive chapter in the section 1. And in India also, we are setting up a separate supervisory authority. Consent, explicit consent, implicit consent, and implied consent. Explicit consent is when a user takes an affirmative action. Implicit consent is like we understand when you, for example, when you came into the session, you gave your personal detail. It is a sort of an implied consent, and implicit consent is also very close to it. So implicit consent is involves affirmative action on the part of grantor, but heavily influenced by the context, right? For example, uploading a picture of themselves to a forum for a free stock of photos. And also implicit consent is implied consent is when you passively grant your permission part of this activity just because you are part of that particular action, right? Celebrity walking on the red carpet to a premiere of a movie is obviously you are implied that there are going to be people taking photos, right? So it's an implied consent that when you do this activity, you're part of that. You understand that there are certain personal information is going to be away. So for example, when I gave this particular webinar, I gave out a lot of personal information about me. So that is understood that I have given an implied consent for this particular activity, right? Opt-in versus opt-out. Opt-in versus opt-out is very clear, which I explained to you by doing a clear action. And opt-out is you need to remove the tick mark which is there in the checkbox, right? That is the opt-out consent. Double opt-in is not applicable in GDPR. So double opt-in is like you need to do a two set of actions to confirm to give a opt-in. And there are other ways. For example, the right hand side of this particular image shows you what is a valid consent and what is an invalid consent. For example, giving a right both options of declining and accepting, and also taking a audit trail of consenting, which is I understood. So for example, even there is majority of the website in the European Union still have problems when it designing a cookie banner. You need to provide all possible different cookies which are getting collected. There are different categories of cookies like analytical cookies, marketing cookies. You need to list what are the different categories of cookies which are there in the website, and then give option for the user to for selectively give preference for each of the category. All right. So these are something which is essentially required by GDPR, but there's a lot of things which are going in that particular domain of cookie consent and cookie monitoring. It's an evolving domain. Again, there's a lot of design factors involved there. Companies are now streamlining in terms of how a cookie banner is being designed. All right, that sums up this chapter. The final chapter which we are going to discuss today is data subject rights. So data subject rights, there are minimum of 8 questions and maximum of 11 questions. So there are 8 data subject rights. We will look at them one by one. The first is right to information. Under right to information, for any processing activity, you can get a sort of a confirmation whether you are processing my personal data or not. Right to access is very simple. You can get a copy of your personal data, whichever is getting processed by the organization. Right to rectification is whenever you are requesting your personal data to be changed, that is related to the accuracy principle, that is a rectification. Right to erasure is a very interesting data subject rights that you want the personal data to be deleted from the organization, understand that right to erasure is not an absolute right. You need to look at, for example, the right hand side table gives you the interplay between data subject rights with the lawful basis, right? You cannot use erasure for all the lawful basis. You can use it when it's based off consent and contract or legitimate interest or vital interest. You cannot use erasure when it's based on legal obligation or public task. Okay, so these interplays are very, very important when it comes to the exam. We will discuss them in detail during my course. Right to restrict processing. Whenever an accuracy of processing is contested, or when there is a lawful basis is not accurate, you are not you are demanding the company to not further process my personal data till there is a clarification, right? You have a disputed case, and you are awaiting a judgment, right? So in that case, you can ask the company to put a pause in processing. That is called right to restriction. Right to portability. For example, you are under with one insurance company and you want to transfer the personal data when you are moving to another insurance company. So instead of creating one more digital footprint, you can ask the existing company to share your KYC form to the next company, right? This is called data portability. So very rarely used. So now people are aware about this particular right. So the intention is to reduce the digital footprints of your personal data. Right to objection is for certain categories, which is like public interest, legitimate interest. You can use your right to objection, which is objecting for the personal data processing, and it is the responsibility of the organization to prove that it is a valid legitimate interest and it's a valid public task, right? Basically, it has to overpower the data subject right of objection. So then only it will stand valid. So you need to do appropriate documentation, and you need to give a justification whenever data subject raises a right to objection. The final is in terms of right against automated decision making. What is automated decision making? For example, if you apply for a bank loan or a credit card, there could be an automated system to measure your credit worthiness, right? The system measures based on the input details provided, and it could give you a credit score, and the credit score can be used to take a decision in terms of giving you a loan or a credit card. So this is called automated decision making. When there is a decision making which is done purely by a system and it has a legal impact on the data subject, then this is called then there is a right under GDPR that you ask the company to not subject you to such automated decision making. All right, so this needs to be clearly informed during the notice that you mention there is a processing activity that involves automated decision making, right? So this interplay between your data subject rights and the different lawful basis is a very important exam question. So kindly pay attention to it and understand it very clearly. When it is based on consent, you cannot exercise right to objection because you gave the permission for the processing activity. You cannot object it later, right? It doesn't make sense. That's the reason you cannot raise right to objection when it's based on consent. But what you can simply do is remove your consent, right? That's the easiest way to object it. In the contract, again, you understood the terms and conditions, then you entered the contract, so you cannot object it later. And the third is legal obligation. Under legal obligation, it's a big no-no because it's a legal requirement. You don't have option for any of these rights. Vital interest, you can ask for erasure of the data once you are well. You don't want the data to be there with the hospitals, then you can obviously raise this request, but the hospitals will be again bound by certain regulatory requirement. And finally, you cannot actually use it for data portability or right to objection. It's not even a valid possibility. Public task, again, you have a very limited right. You cannot raise erasure or portability, but you can object to certain public task. For example, certain public task needs to be demonstrated during COVID situation. There is a lot of personal information was used by the authorities. Certain level of such activities you could object that you are not comfortable to provide such information for certain like your genome related activity, personal data, you might be not comfortable, right? So you can object to certain activities, and it is the responsibility of the government to demonstrate why it is a vital or important public task. And the last is legitimate interest. You cannot port a data under legitimate interest, but you can always request for erasure and objection.